Mark, I understand that the members of your union are largely employed by school districts. What is the typical process a school district must go through to fire an employee?
Well, in New York State, I'll address teaching staff. There is a process within the education law that's commonly referred to as Section 3020A of the education laws of the state of New York. And that's the process that spells out how tenured teachers are to be disciplined. Now, first of all, teachers in the state of New York are on a 3-year probationary period. So for their first 3 years of employment, they in effect are at-will employees. They can be dismissed at any time without cause during that 3-year period. If at the end of their 3 years, the superintendent of schools under law, only the superintendent can recommend that the employee receive tenure, and only the Board of Education can confer tenure. So there's a 3-step process. First of all, the employees are evaluated on a regular basis by their building principals. Those evaluations are then forwarded to the central administration. The superintendents will meet with the principals from time to time during those employees' employment and review their process with them. Many school districts are paying closer attention now to those evaluations because they do not want 3 years to go by and suddenly realize that this person isn't going to make it or isn't going to be a good fit, and they've just wasted 3 years on a teacher that they don't continue to employ. So many of them will really, after that first year, make a decision to let those folks go, because maybe they aren't making it or meeting the district's needs to be a good, competent classroom teacher. But after the end of 3 years, the superintendent of schools wants to retain you. He or she recommends to the board that the teacher receive tenure. The Board of Education then has to vote on it. It's in the board minutes, and the teacher now has tenure. Now, what does that mean? What it means is that the teachers have a right to due process if they're going to be disciplined by the district. That includes a hearing prior to being served with charges. The employee is given the opportunity to respond to the allegations. And if the district does not agree with that response, they then have an opportunity to prefer charges against that employee. I'm seeking a penalty anywhere from a written warning up to and including dismissal. The employees then have to respond to the charges, and there is a hearing that's set up, a due process hearing, where there are a panel of arbitrators across the state of New York who are in effect employed by the Department of Education, who will be assigned to hear this teacher's case. There is a process of discovery where the district has to provide to the union and the employee the basis for the allegations for the misconduct or whatever the charge is. That hearing officer is a true neutral. That person is a labor relations professional with a whole host of experience in deciding these kinds of cases, because let's face it, termination in the workplace is the ultimate form of capital punishment in the workplace. Nothing more severe can happen to you than to lose your job, and your career as well can be threatened by this kind of an act. So everybody treats the process very seriously. The hearing officer will then schedule a series of meetings. The employer in this case obviously has the burden to show that they have cause for seeking the penalty that they're seeking. They proceed with their case. They're free to call all of their witnesses. The union has the opportunity to cross-examine those witnesses. The union can then put on its case. The member will be a witness. The employee is being targeted for discipline, and the union also can call witnesses on that member's behalf. Following the completion of those, and keep in mind, this can take time. These generally are multi-day hearings. Lots of testimony, lots of exhibits. Following the hearings record being closed, the parties then submit what are called the closing statements or a closing brief, and following the receipt of that, The hearing officer generally issues a recommendation and a finding of fact within 30 days, and that finding is binding upon the parties.
Okay, and with that process, how often do the employers you deal with fail to go through the correct steps to fire an employee?
Let me answer that two ways. First of all, they generally do not fail to follow the correct steps. The law is very clear. It's been around for a number of years. There are a host of management attorneys in Western New York, where I work and live, and that are very familiar with the education laws, and they advise their school districts. They're involved in the process from the beginning, so they don't make technical mistakes that can cause a case to be dismissed on a technicality. Correct steps to fire an employee. Sometimes the employer, the school district, in their investigation, they don't do a proper investigation. They don't meet what neutrals have termed to be a test, the 7 test of just cause. The penalty that's being sought may in fact be too severe, whereas the penalty doesn't fit the crime. The district may be seeking termination, but really something short of that, maybe a long-term suspension of some nature, was really the appropriate penalty. You've got a longer-term employee who's got a good work record and makes a mistake or does something contrary to district policy. If they've got a good work record, chances are that they've admitted they made a mistake. Termination isn't really the proper penalty, maybe something short of that. So it's not unusual for a lot of these cases to settle. I'll get involved in settlement discussions because it's to everyone's benefit to resolve the case rather than go through a lengthy hearing. Lawyers on their side, lawyers on our side, paying the cost of the hearing officer, transcripts. We're talking, over $100,000 by the time everything ends up with all the days of hearing. So it's really to everybody's benefit to try to resolve the case before it goes to a hearing. And my guess is more than half of the cases I get involved in personally do settle before charges are filed.